Addressing the failure by His Excellency the President to appoint judges that have been nominated by the Judicial Service Commission for appointment to various divisions. And we'll begin by thanking the media and indeed the entire nation for always supporting the judiciary in the administration of justice. And we hope that this partnership will continue, and ultimately the beneficiary is Wanjiku. And this nation has evolved over time. In the old constitutional order, the president had express powers to appoint judges. This framework of appointment led to a lasting perception that judges were beholden to the presidency and that the judiciary was an appendage of the executive arm of government. This perception culminated to the unfortunate events following the disputed presidential election of 2007. Needless to mention that parties involved refused to challenge the results in court. Therefore, it is against this backdrop that Kenyans spoke with a loud and decisive voice in 2010 and gave themselves a new constitution, and partly to remedy the mistakes of the past. Article 172 of the Constitution changed the framework of appointment of judges by removing the direct power of appointment from the president to an independent state organ, being the Judicial Service Commission. It will interest Kenyans to know that the JSC is the only commission where the executive is represented. In exercise of its mandate, the Judicial Service Commission nominated 41 members for appointment by the President. 11 of these members were nominated for appointment to the Court of Appeal, and 30 were to the Environment and Land Court and Employment and Labor Relations Court. It is noteworthy that the executive, having representation in the JSC, participated in the exercise. Statistics show that there are about 400,000 cases being filed per year against a diminishing number of judges and magistrates. The backlog, and here backlog means cases which are older than 1 year, as at the 1st of July this year, stands at 372,928 cases. Against these boggling numbers, we currently have 644 judges and magistrates combined, serving a population of 48 million people. By way of example, countries like England and Wales, with a population of 58 million, has 3,210 judges and about 22,000 lay magistrates, which explains why the case completion period in those countries is quite shorter. One of the pillars of sustaining judicial transformation, commonly called SJT, blueprint is, and I quote, action on case backlog. And despite their small numbers, judges and magistrates have been burning both ends of the canton to reduce case backlog. They can only do so much with this limited number. And these efforts will amount to naught. given the few numbers. And this has the net effect of slowing down the administration of justice. Wanjiku cannot celebrate when his or her case cannot be heard and determined in the shortest time possible. It is against this background that the Judicial Service Commission advertised, shortlisted, and interviewed applicants for various vacant positions. Upon selection, the names were forwarded to the President for appointment as required by the Constitution. Regrettably, 4 months down the road, the President has not appointed the nominees. And this is an affront to the Constitution and the rule of law, and waters down the institutional independence of the judiciary. It takes us back to the old order which Kenyans assertively put behind them. Article 1 of the Constitution vests sovereign power in the people of Kenya, and this power is donated to the 3 arms of government. This power should only be exercised in accordance with the will of the people. And it is for this reason that we call upon the President to stay true to his oath of office to uphold the Constitution by appointing the judges as nominated by the Judicial Service Commission. That's what our statement is all about. We will invite 3 questions which will be answered by the President of the Association. So if we have at least 3 questions, we can take them, then we can respond to them. Thank you so much.
From the delay that we're talking about, our feeling about the stalemate and the matter that has now resulted in going to court is that Wanjiku does not seem to understand why there's a delay. So every time when they come to court and they find that the matters are not being handled, they blame the judiciary. You find there's a lot of negativity outside where everybody says, and that's why the majority of Wanjiku will not be with us. Because as far as they're concerned, the matters are delayed. If I come to court and I stay there until 3 p.m., 4 p.m., and I do not get my case heard, they will not understand the intricacies which are behind that particular issue. So it's for that reason that we're saying that beyond even the backlog, the perception of the Kenyan public is that the judiciary is not working. Yet we've heard that we are very, very few people compared to a population of 48 million. The other thing that we're saying, even as we do the statement, is that remember that the purpose of the statement also is to see whether we have sat down and looked and seen that the parties who are in court perhaps maybe might need to look at a different approach and see how else can you resolve this issue, as opposed to necessarily going to court. Because if the matter goes to court, at the end of the day, if there's a stalemate, then what happens? So we need to look for a solution. There's the limitations that we have as regards commenting on these documents which are in court because of the matter is sub judice. Sub judice means that we cannot overstretch and really comment because the matters are still pending in court. Yeah. Because at the end of the day, it will be a determination of the court once it sees the documentation that is there to make a decision whether it is correct or it was not correct. Yes. There is no time limit within which you should be able to, where the president is to appoint the judges or nominate the judges. So there was a lacuna in that regard, because obviously some of these issues were not anticipated. It was expected that the minute the JSC nominates, then the president would appoint. But of course now certain issues have arisen. We, just like you have said, we are not parties to the case, but we've also heard that there are certain grounds of misconduct that have been said. So it was not something that was anticipated from the very beginning. Again, also because we said that the matter is in court, we do not want to comment too much on that because we do not know the intricacies of the case, and we don't want to meddle where we are not there. Now, on the issue of what will happen if the president still does not appoint, and that's where basically I was trying to say that, any court case that you have, the opponent can refuse to adhere to court orders. But in a situation like this, you will not say, let's take the president for contempt of court. No, you can't, because he also has his mandate and say, if the Constitution does not give me a basic timing on which I'm going to do this, and if I'm going to do it, I'll do it. So I go back to the point and say that at the end of the day, this issue will only be resolved by people looking at different options. How can we resolve it? Because you can get a judgment and the person will say, I will not adhere to that judgment. So what are you going to do? The person who is appointing is the president. So even if the persons have been nominated by the Judicial Service Commission, they cannot swear these judges themselves. So we are looking now at a situation, because beyond this, that question is very pertinent. What will happen? So will we stay this way? Yes, the backlog remains the way it is. Somehow, we are calling upon the parties to see how best they can be able to help the nation.
Maybe if I can, I may just add on what Madam President has said. Part of the reason why we are issuing this statement is that the President will take heed to what we have said. And we really hope that he's going to appoint them. And we don't want to assume that he may overlook what we are talking about. But what we're also saying is that the media, who, like I said, is a friend to the judiciary, it's a friend to all of us. Really, we need to talk about these issues. Let's make Wanjiku understand what is happening. Because ultimately, the person who is suffering is Wanjiku. It's not even the individual judges, it's not the individual magistrates, but it's Wanjiku who wants his or her case determined in the shortest time possible, so that they're able to realize the fruits of their judgment. So our hope is that there will be a lot of discussion around this issue, not just by us, but by every other person. And by extension, we are calling upon all Kenyans of goodwill. We are calling upon even the international community to come in and talk about these issues. For the independence of the judiciary, the independence of the Judicial Service Commission, there are issues which are pertinent, there are issues which are paramount, and there are issues which cannot be compromised. But going forward, we hope that, like Madam President has said, these lacunas will be filled so that we cannot find ourselves in the situations we are in.
The country in general is facing austerity measures. We are not the only institution that suffered budget cuts. But we also had to, I do not want to comment on the statement by the CJ because I'm not really qualified. But the bottom line is, from the speech that, or rather the speech that the CJ gave, it was clear that the budget we had presented was, as approved, was already very much reduced. Then subsequent to that, when you have budget cuts that go to paralyze your operations, it was important and it was imperative that we come out strongly and make it known to Kenyans and everybody who would be interested in knowing the position that we could not function with the budget cuts. I wouldn't say it was an attempt to interfere directly with the independence of the judiciary, but we felt the need to speak out so that it is understood out there that with what had been allocated, it would be difficult for the judiciary to implement.